Article 18, Animal. Canon 1510. An animal is any valid form attributed to an organic life form that is not a member of the Homo sapiens species or equivalent higher order life form. Canon 1511. A member of the Homo sapiens species can never be depreciated to a separate class attributing they possess the lesser form of an animal. Canon 1512. Any law, precept, or decree that separates a class of Homo sapiens into a lesser class as forms of animals is automatically null and void from the beginning. Article 19, Notion. Canon 1513. A notion is any valid form attributed to an object or concept that is neither a member of the Homo sapiens species or other higher order life form possessing a civilized culture. A right, or good, or right of use are examples of a notion. Canon 1514. A member of the Homo sapiens species can never be attributed the form of a notion. Any law, precept or decree that attributes the form of a notion to one or more members of the Homo sapien species is automatically null and void from the beginning. Article 20, Thing. Canon 1515. A thing, also known as rem or re in Latin, is a temporary form being the object of one or more rights against which there exists a dispute or ongoing controversy before a competent forum of law having jurisdiction. There are three general kinds of things. I. Things real, also known as things immovable and corporeal, being lands, tenements and hereditaments, and 2. Things personal, also known as things movable and incorporeal, being goods and chattels, and 3. Things mixed, being things partaking the characteristics of real and personal such as a title, deed. Canon 1516. The form of a thing, also known as rem or re, cannot exist except within the bounds of a matter before a competent forum of law. I. The effect of treating the object of a right in dispute as a thing is to cause it to be converted temporarily into a form of property or rem or re itself, and 2. By tradition in Western Roman law, a person was prohibited from being converted into a thing. However, legal persons are now commonly treated as things, and 3. Things are generally construed according to that which was the first cause of the dispute. Hence, the descriptions used in the first cause and subsequent form of action, generally determines the labeling and description of any things in dispute, and 4. The status of an object as a thing in rem or re only continues to exist, so long as the matter which first converted it into a thing continues, such as a case of bankruptcy sine die, deferred to a latter date, and v. When a thing is the subject of an action of recovery, things in action, or things in entry, such property cannot be granted over until the action ordered by the competent forum of law is completed, and 6. The status of an object being treated as a thing dissolves when purchased, sold, bound or granted through a special form of agreement known as a covenant contract, also known simply as a contract. Canon 1517. A member of the Homo sapiens species can never be attributed the form of a thing. Any law, precept, or decree that attributes the form of a thing to one or more members of the Homo sapiens species is automatically null and void from the beginning. Article 21, Word. Canon 1518. A word is a notional form using symbols and sound to signify meaning, having historic origin normally as part of a language. Canon 1519. All words and their meaning of all languages used to promulgate these canons are subject to the Euclidean lexicons of language. No other meaning or interpretation from any other reference, dictionary and glossary is permitted to be used unless it is sourced from an Euclidean lexicon. Canon 1520. The coupling of words together shows that they are to be understood in the same sense. Therefore, No one is able rightly to interpret one part of a form of words from the whole, unless the grammar used permits it. Canon 1521. Departure from the signification of words is not permitted unless it is evident that they are not conformable to the intent of the whole. Canon 1522. Subsequent words, added for the purpose of certainty, are to make clear the preceding words which require the certainty. Words referred to are to be considered as if incorporated. Canon 1523. Subsequent words, added for the purpose of clarity only, must be isolated by a consistent form of open and closed square brackets. When interpreting the whole, a form of words isolated by open and closed square brackets is to be taken as not existing on the page. Canon 1524. Subsequent words, added for the purpose of list or details of citation, must be isolated by a consistent form of open and closed rounded brackets. When interpreting the whole, a form of words isolated by open and closed rounded brackets is to be taken as secondary form on the page. Canon 1525. Words to which reference is made in an instrument by valid citation have the same effect and operation as if they were inserted in the clauses referring to them. Canon 1526. In non-formal use, general words are to be understood generally. In formal use, general words must be narrowed in meaning either by exposition of the subject or by inclusion in an attached glossary of terms. Canon 1527. Whilst error in form is to be avoided, neither false spelling nor bad grammar vitiates a deed. Canon 1528. The underlining of a word indicates it to be in error or dispute. The striking of a word by a line indicates it is to be removed. Canon 1529. The typography of a word has no material significance to a particular form unless it clearly states in law and statutes such use for that form is required. Canon 1530. The color of the typeface used for a word has no material significance to a particular form unless it is clearly stated in law and statutes such use for that form is required. Canon 1531. Words may not to be taken to import a false demonstration which may have effect by way of true limitation. Canon 1532. No man, woman, or person is at liberty to disregard the letter of a canon, in favor of supposed intention. Article 22, Document. Canon 1533. A document is a notional form of spiritual or temporal written instrument of one or more pages, with each having a front face or obverse and a back face or reverse. There are only five valid forms of documents: supreme, superior, ordinary, general and inferior. Canon 1534. A valid document is any document that conforms in form to the requirements prescribed by the body of canon law known as Astrum Maiores Divini Canonum in accordance with Pactum de Singularis Coelum. Canon 1535. A supreme document is a valid document issued and sealed by a supreme official person, registered in the Great Register and Public Record of one heaven and existing firstly as a supreme spiritual and ecclesiastical instrument and secondly as a supreme temporal ecclesiastical instrument possessing full living personality. There is no higher, more powerful, nor authoritative document than a supreme document. Canon 1536. A superior document is a valid document issued and sealed by a superior official person, registered in the Great Register and Public Record of one heaven and existing firstly as a superior spiritual and ecclesiastical instrument and secondly as a superior temporal ecclesiastical instrument possessing full living personality. It is the second highest and authoritative document of all. Canon Canon 1537. An ordinary document is a valid document issued and sealed by an ordinary official person, registered in the Great Register and public record of one heaven and existing firstly as an ordinary spiritual and ecclesiastical instrument and secondly as an ordinary temporal ecclesiastical instrument possessing full living personality. It is the third highest and authoritative document of all. Canon 1538. A general document is a valid document issued and registered in a great register and public record of an Okadian society that is not issued by an ordinary, superior, or supreme official person. Canon 1539. An inferior document is any document issued by an inferior person such as a Roman person or inferior juridic person. No inferior document may ever be allowed to claim superiority over a general document, ordinary document, superior document, or supreme document. Canon 1540. All documents, whether valid or invalid, have at least one obverse and reverse with the primary and most ancient purpose of the front or obverse as the window transmitting the purpose and message of the document, whilst the reverse provides the window transmitting any formal reply, or rebuttal. Canon 1541. The physical alteration of any document, whether it is valid or invalid, without the permission of the original author is an injury that shifts any liability to the party who altered the document without permission. Canon 1542. By definition, an author cannot deny the existence or validity of their own documents without causing injury and accepting all liability. Therefore, the return of any document to its author with a perfected reply attached and sealed to the reverse cannot be denied or ignored without the author causing injury and accepting all liability. Canon 1543. When a separate document is attached and sealed to the reverse of the first document, then a reply is perfected in accordance with the most ancient traditions of documents without injury. Article 20. Article 23. Land. Canon 1544. Land is a fictional term used to define the solid terrestrial surface of a planet based rather than any predominantly liquid surface such as a sea or gaseous structure such as an atmosphere or air. Land is also used as a term synonymous with all the solid terrestrial surface of planet Earth. Canon 1545. Land is physical matter within space existing in accordance with natural law as defined by these canons. Therefore, as an object, it cannot be owned by a fiction such as an owner, as fictions can only own other fictions. Canon 1546. Except for the divine creator, by divine law and natural law physical matter within space cannot own one another, only themselves. Therefore, the divine creator, also known as unique collective awareness, is the only true owner of all land in the universe, including the planet Earth expressed into divine trust. Canon 1547. In order to enable the lawful ownership of land, a valid fictional form derived from the objective existence of land is required. This is accomplished by undertaking a valid survey of the land and creating a description of its metes and bounds, and then connected in a succession of surveys to the ultimate survey being the rules and mind of the divine creator. When this exists, a valid location may be proven to exist, being a fictional form of land capable of being owned. Canon 1548. When a particular location owing its existence to the first rightful claim of ownership of the divine creator to all land is lawfully conveyed into a true trust, this is called divine right of use, or divinity, representing the highest right of use above all other claims of right and title. When some or all of these rights are then conveyed to a superior trust, this is known as realty, or real property, being first right of use of land and immovables by divine right, divinity. Canon 1549. In accordance with the will of the divine creator, the sacred covenant Pactum De Singulis Caelum, and the 7 sacred pronouncements of Okadaya, the divine rights of ownership in all land, surveyed as valid locations, has been expressed into true trusts administered by the Society of One Heaven for the benefit of all men, women, higher order beings, animals, and life forms living now and forevermore. Canon 1550. In accordance with these canons, the sacred covenant Pactum De Singulis Caelum and the 7 sacred pronouncements of Okadaya, any and all claims of land ownership, conveyance, or trusts that are not in accord with these canons and the will of the divine creator are henceforth null, void. From the beginning. Article 24, c. Canon 1551. C, also known as C, is a fictional term used to define a large body of liquid covering the surface of a planet based rather than any exposed solid terrestrial surface such as land or gaseous structure, such as an atmosphere or air. The sea is also used as a term synonymous with all the liquid surfaces of planet Earth. Canon 1552. Sea is physical matter within space existing in accordance with natural law as defined by these canons. Therefore, as an object, it cannot be owned by a fiction such as an owner, as fictions can only own other fictions. Canon 1553. Except for the divine creator, by divine law and natural law physical matter within space cannot own one another, only themselves. Therefore, the divine creator, also known as unique collective awareness, is the only true owner of all seas, also known as seas in the universe, including upon the planet Earth expressed into divine trust. Canon 1554. When sea, also known as sea, owing its existence to the rightful claim of ownership of the divine creator is lawfully conveyed into a true trust, this is called realty, or real property representing the highest right of use above all other claims of right and title. Canon 1555. In order to enable the lawful ownership of the sea, a valid fictional form derived from the objective existence of the sea is required. This is accomplished by undertaking a valid survey of the seas and creating a description of its watermarks, shores, depths and distances, and then connected in a succession of surveys to the ultimate survey being the rules and mind of the divine creator. When this exists, a valid location may be proven to exist, being a fictional form of sea capable of being owned. Canon 1556. When a particular location owing its existence to the rightful claim of ownership of the divine creator to all seas is lawfully conveyed into a true trust, this is called realty, or real property representing the highest right of use above all other claims of right and title. Canon 1557. In accordance with the will of the divine creator, the sacred covenant Pactum De Singulis Caelum, and the 7 sacred pronouncements of Okadaya, the divine rights of ownership in all the seas, surveyed as valid locations, has been expressed into true trusts administered by the Society of One Heaven for the benefit of all men, women, higher order beings, animals, and life forms living now and forevermore. Canon 1558. In accordance with these canons, the sacred covenant Pactum De Singulis Caelum and the 7 sacred pronouncements of Okadaya, any and all claims of sea ownership, conveyance, trust that are not in accord with these canons and the will of the divine creator are henceforth null, void from the beginning. Canon 1559. When anyone references, writes or speaks of the sea, first sea, holy sea, or holy sea, it shall mean the seat of power of the Society of One Heaven upon the earth and no other. Canon 1560. Any person, entity, aggregate, or group that claims itself to be the sea, or holy sea in defiance of these canons is guilty of a solemn offense against all of heaven, all spirits that have ever existed and the divine creator. Such an entity in such serious ecclesiastical dishonor has no spiritual power nor authority whatsoever. Article 25, Building. Canon 1561. A building is a fictional form created through the combined action of a descriptive engineering plan and registration of a structure or edifice upon a valid cadastral location. Canon 1562. A building is always attached to a valid location and not vice versa. Canon 1563. Registration of a valid building is when a valid engineering plan is registered in the Great Register of the Hokkaidan Society as the one true and accurate current plan of the building. Canon 1564. Any building of a particular cadastral location that is not properly registered into the Great Register of a Hokkaidan Society is automatically invalid, including any and all associated land title, rights, claims, contracts and agreements. Article 26, Good. Canon 1565. A good is a fictional form of notion held in trust determined to be useful and therefore possessing a value measurable by some unit of value. As a good is a form of notion, a valid good may be either tangible, object, or intangible, concept. Canon 1566. The term product is equivalent to a tangible object and therefore a tangible good. The term service is equivalent to an intangible concept and therefore an intangible good. Canon 1567. A member of the Homo sapiens species can never be attributed the form of a good. Any law, precept, or decree that attributes the notion of a good to one or more members of the Homo sapiens species is automatically null and void from the beginning. Canon 1568. All goods are held in trust by virtue of the rights of their creation, storage, conveyance, use or administration. Canon 1569. There are only 5 valid types of goods: supreme, true, superior, general and inferior. I. A supreme good or a supreme ecclesiastical good is any good belonging to a supreme trust, and 2. A true good is any good belonging to a true trust, and 3. A superior good is any good belonging to a superior trust, and 4. A general good is any good belonging to a merchant, union, location, clan or temporary trust, and v. An inferior good is any good not belonging to a supreme, true, superior or general trust such as an inferior trust formed by the policies, statutes, and regulations of the Roman cult, also known as the Vatican. Canon 1570. No good can exist outside of a valid trust. Therefore the highest right of ownership of all possible goods is the Society of One Heaven in accordance with these canons. Canon 1571. Any claim of higher right of ownership of any good than the Society of One Heaven is automatically null and void from the beginning. Canon 1572. When any person subjects goods that otherwise should be supreme, true or superior goods into being inferior goods, then such a person loses all rights and such rights of goods automatically transfer to the relevant Hokkaidan society. Canon 1573. As supreme goods are the highest and most valuable form of goods, supreme goods are not permitted to be traded, exchanged, or sold. Canon 1574. Only general goods are permitted to be exchanged, gifted, granted, sold, traded and securitized in accordance to these canons.